The Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. Before you call the case, let me welcome high school students from Milton. Well, it's wonderful to have you here. We really appreciate you coming, and your teacher has been a solid, consistent presence in our courtroom every year, and that says a lot for your school. And for him. So nice to see you all. We'll visit later, but we've got some arguments to take. So if you would please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont v. Rain Kolts, case number 25 AP 079. Representing the appellant, Rain Kolts, is Attorney Marshall Paul. Representing the appellee, State of Vermont, is Attorney Evan Meenan.
Thanks very much. Good morning, counsel. We'll hear from the appellant first, of course. Please come on up. And if you would, before you start your argument, introduce yourself and your client.
Thank you, Your Honor. My name is Marshall Paul, and I represent Rain Kolts.
Thank you.
In this case, the state elected to charge Mr. Kolts with 2 aggravated sex charges. That means the state chose to require itself to prove an additional element beyond what's normally required in a sex assault charge. And that is to prove that the victim in the case was under the age of 13 at the time that the alleged acts occurred. And in this case, the state simply failed to put on that evidence. And there was options available to the state.
Paul, couldn't that be inferred from the facts as testified by the complaining witness that 6th grade, her date of birth, May, all the different courts saying taking the evidence most favorable to the state, said that you could find by circumstantial evidence that the age was proven?
No, Your Honor. And I think the state makes that argument in detail in its brief. And suggests that it's just a matter of simple math and provides a number of dates, including the victim's date of birth, the date that she graduated from high school, and the fact that the assault occurred in 6th grade, and says that from that, you can figure out that she was under the age of 13. But you can't, because it's not a matter of simple math. It's really a matter of algebra. And no matter how you do that equation, it leaves an unresolved variable, which is
Simple math different than algebra, is that?
Well, simple
math
math.
just says pluses and minuses. In algebra, you got to put some other figures in there, I guess. Is that how?
It does. In algebra, you can wind up with an unresolved variable, and here you do, which is the amount of time it takes to get from 6th grade to graduation. There was no evidence about that in this case, nor was there evidence about when she graduated. So the jurors were forced to rely on an inference upon an inference, which is first.
Go ahead, finish your thought.
Which is first to infer that she graduated in 12th grade. Not everybody graduates in 12th grade. And second, to infer that it took a particular number of years to get from 6th grade to 12th grade, which is also not the case for everybody. Many people take either shorter or longer periods of time than other people to get to 6th grade. And so to suggest that jurors should use their own common sense or their own experience to fill in those evidentiary gaps is really going beyond what's ever been said about it. We've always said that jurors can use their common sense and their experience in the jury room, but that doesn't mean that they're allowed to fill in evidence that wasn't presented in court with their own experience. And that's really what the state's argument is it's inviting.
Paul, aside from the inference upon inference, the impermissible inference upon inference, there's also it's the highest standard that we know in the law to prove an element of an offense, and that's beyond a reasonable doubt. So your argument is you can't get to that standard of proof if everything is an inference upon an inference. We often know that facts can be proven by circumstantial evidence. There's no direct evidence here. Nonetheless, all those inferences cannot meet the standard of beyond a reasonable doubt.
I do agree with that. That does not meet the standard of beyond a reasonable doubt. And I would go further to say that these are more than inferences. This goes beyond inference to speculation. A lot of courts have looked at the distinction between what is a permissive inference upon which an essential element of an offense may rely and what is speculation. And this really crosses that bridge.
All right, now I'll go back to my question if I might. Didn't NH say to Detective Whitney that the abuse stopped when she was 11 or 12?
Variously, she said that the abuse stopped when she was 11 or 12 and that the abuse occurred when she was 12 or 13. And specifically the abuse in the barn, she was asked about that. And she said that that occurred when she was 12 or 13. That was the evidence before the jury.
And that's not enough.
No, because that's equivocal on an essential element of the offense. It would be the same as if a victim said, if asked, was that the person who did it? That it either was or it wasn't. It could satisfy the essential element or it couldn't. Or if someone was asked,
I don't follow. What is the specific fact that you are saying was equivocal?
whether or not the abuse occurred when she was under the age of 13 or over the age of 13. If she was under the age of 13, then the evidence would be sufficient. If she was over the age of 13, it would not. And her testimony, when she was asked directly, what age did this occur at? She said 12 or 13.
I want to make sure you talk about the prior bad act evidence. Would you, if no one else has a question, if you would mind turning to that?
Certainly, Your Honor. I think in this case, the prior bad act evidence coming in is obvious. And the state's only argument regarding the prior bad act evidence is that the door was opened. And that once the door was opened, the prior bad act evidence just flows in. And I think that's wrong on two counts. First of all, the door was never opened in the first place. The entire notion that the door was opened was has to be based on some very specific testimony. And so I think it's really important to look at.
And it's testimony of your client.
It's testimony of my client, and I think it's important that the court looks at it. It's on page 154 of the May 2nd transcript. And specifically, my client was asked two questions that the state claims opened the door. The first was, isn't it true that you once said that your wife's port for her diabetes was a sexual turnoff for you? And his answer was, I don't remember that. The follow-up question was, you don't remember saying that? His answer was, I don't. He did not at any point deny that his wife's diabetes port was a sexual turnoff. He simply said he didn't remember. The second question was, you remember a time when your sex life with your wife went downhill? His response was, do I remember a time when it went by, when it started to go downhill? Is that what you're saying? The follow-up question was, when it was, isn't it true that your sex life with your wife, Karen, was not good? No time frame in there, just a bare question. Was there a time it was not good? And his answer was, it didn't have anything to do, it doesn't have anything to do with Karen. It has something to do with age and erectile dysfunction. He did not contradict what he said in his 2014 interview. She didn't ask the question to say, in 2014, did you say that your sex life went downhill because of your wife? She just asked vaguely, has your sex life with your wife ever gone downhill? This is 10 years after the 2014 interview that she's referring to. This is at trial in 2024. So at no point did he actually contradict his statements made in the interview, which means the door was never open in the first place. But even if the door was open, that's only a small part of the analysis. The door opening doctrine really allows for the correction of misinformation when that misinformation is material and when the correction is important enough to the case that the admission of otherwise inadmissible evidence is necessary to complete the picture for the jurors. So the fact that the door was open is only the first part of the analysis. The second part of the analysis is whether or not is the question of materiality. Was the jury misinformed about something material to the case? And in this case, the question that the jury was allegedly misinformed about, but in fact wasn't, because all that Mr. Kolts said was they didn't remember his answer to the question, was what his sex life with his wife was like 10 years prior, and whether or not he said something about a diabetes board 10 years prior.
So where's the prejudice here?
The prejudice is because this is the most prejudicial type of information that can come in. It is,
The
This is-
most prejudicial, I don't see why.
the prejudice in this case, excuse me, I apologize. The prejudice in this case is because this is the most prejudicial information that can come in, because the prosecution was allowed to ask a question, which was, did you say to Detective Ruth Whitney in 2014 the following things? And what that said to the jury, because Detective Ruth Whitney had testified for pretty much the entire day before, and the state spent pages and pages of testimony propping up her credibility by explaining that she was a specialized investigator, that for years and years, she had done
So
nothing.
if I can just interrupt you, the prejudice is by implication, right?
Yes,
It's by implication, implied from the detail that the state went into with respect to the qualifications of Ruth Whitney. That's your argument, isn't it?
yes, and it's more than just implied, because given,
Well, how so?
given what the
Yeah.
court knew about Ruth Whitney, that would be like suggesting, for example, that if a jury was told that a defendant visited an oncologist, that we shouldn't presume that the jury presumes that the defendant has cancer.
Yeah,
Detective
but there
Ruth
was
Whitney.
evidence about Ruth Whitney, I thought, that talked about how she was involved in cases other than sex offense cases. So
And-
the implication is not as clear as what you're suggesting.
But first of all, this court has been clear, and other courts and commentators have been clear, that any evidence of prior bad acts, not necessarily specific evidence of identical prior bad acts, is nonetheless incredibly prejudicial and the worst kind of
Mr. Paul, there's significant amounts of connections that need to be made in order for it to get prejudicial, prejudicial. So you got to make lots of connections to say that he was being investigated for a sex crime back in 2014. I don't see how that, because that's something that never came up in the case.
I think it's a pretty quick connection for jurors to make, that if Mr. Kolts was on trial in 2025 for a sex crime against a child, and that if the jury was told that he was interviewed by the child sex crimes investigator in 2014, I don't think it's a big leap for them to conclude that he might have been interviewed about a child sex crime, and for that not to have come. And it would be one thing if that came in a manner that was admissible in the first place, but the fact that it came in when the door was not even open to it, I think is fatal to a case where that is such prejudicial information.
Well, I know you're running out of time,
I am.
and can we talk a little about the standard the standard that was charged by the court to the jury on great certainty? Before you,
Yes, Your Honor.
thank you. So what is what does great certainty, how does that compare to beyond a reasonable doubt on proof?
The Tenth Circuit is the only court that has ever considered what does great certainty mean in terms of a standard of proof, and it held that it meant clear and convincing evidence. There's been no court in the country that has held that great certainty is an adequate definition of beyond a reasonable doubt, except this court. And as the state points out in its briefing, it seems to be limited to one judge that has ever actually delivered this instruction. So this instruction is an outlier to an extreme. This court is the only court that's ever approved of the instruction, and only one judge in the state is actually using the instruction. So only jurors who are in front of this judge in this state are getting this diminished reasonable doubt instruction. We are
Let me ask you a
such an
question.
outlier. Yes,
Let me ask you a question. This is not the first time you've been down the great certainty road.
it is not.
Why no objection?
I can't answer that, Your Honor. I was not trial counsel. I would say that this court has answered the question enough times that even though I think that this rises to the level of plain error because it's plainly contradictory to cases like Cage v. Louisiana and in Ray Winship, I think it's hard for a defense attorney to raise an objection in the face of so many decisions by this court affirming an identical instruction.
How do you think great certainty compares to utmost certainty?
By every dictionary definition, great is less than utmost. Utmost is the highest. Great, by some definitions, means merely more than average. And the Tenth Circuit, when it looked at what does great certainty mean, equated it to clear and convincing evidence, which is somewhere between, it's certainly not beyond a reasonable doubt. And I see that my time is now up.
Mr. Chief Justice,
Yeah,
may I ask
please,
another
yeah.
question? Thank
Yeah,
you.
Yeah.
So Attorney Paul, you argue that the jury instruction is structural error. And because of structural error, the only remedy is reversal. Does it make a difference if it's not structural error, but it infects the process and the right to due process so integrally that it won't survive plain error? And so therefore it has to be reversed.
I think
Because
that's
you're-
true also, but I think that it's what you just defined is so close to the definition of structural error,
Right.
which is error that's so deeply entwined into the process that it makes it impossible to review for prejudice. I mean, I think the two concepts are so close together that I think you're correct. But I think the concept you describe is very closely related to structural error.
Did you raise, are you raising the plain error argument because it wasn't preserved below? Or is your position regardless, this is structural, it mandates reversal?
My argue is that it's structural and mandates reversal, and in the alternative, that it should be treated as plain, given the Supreme Court's decisions in Winship, Cage, and Victor.
Thank you.
Thank you very much. Your time has expired. We'll hear from counsel for the appellee now, please. And if you would, for the benefit of the record, please introduce yourself and identify your client.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is asking the court to affirm appellant's convictions for 2 counts of sexually assaulting his niece, NH. I'll start off with appellant's sufficiency of the evidence argument, and I'd like to start off addressing that by highlighting the standard of review, because I think it's incredibly important in this particular case. The standard of review is deferential to the jury, and this court has recognized that it will not overturn a unanimous jury verdict unless the state has failed to present any evidence. That's this court's phrase, any evidence to substantiate it. Alternatively, this court has said when the state presents no evidence. Also pursuant to this standard, the evidence must be viewed in the light most favorable to the state, excluding modifying evidence. The state's brief outlines two reasons why the evidence is sufficient. I'll start off with the second, which is that the evidence was sufficient to show that NH was under the age of 13 at the time of the last sexual assault she described taking place in appellant's barn. I want to start there because that issue is very closely tied to the standard of review. Appellant's argument takes that standard and flips it on its head. It relies on modifying evidence, in other words, the possibility that NH took either a longer or shorter time to navigate her educational tract than what most of us have experienced. And it also views the evidence in the light least favorable to the state. As a result, under the standard of review that this court must apply, this court must reject appellant's arguments. Continuing with the last incident that took place in the barn, the state outlined 6 important dates in its brief. NH's birth date in 1998, May 5th, the fact that appellant sexually abused her from 2005 to 2012, that the abuse stopped when she was between 11 and 13, that the last incident in the barn took place when she was in 6th grade. She graduated high school in 2016 and college in 2020, and she was 25 years old when she testified on May 2nd of 2024. It's important to look at what the language in the state's information was when considering these dates. The language in the state's information did not charge a specific act of vaginal penetration. Instead, it alleged that at least one act of vaginal penetration took place between January 1st of 2005 and December 31st of 2011. When you compare that last date to the dates that I previously outlined, it's clear that that charge only applied to the time period when NH was under the age of 13. Because this court is required to presume that juries follow instructions, we must presume that the jury concluded beyond a reasonable doubt that the appellant penetrated NH's vagina with his penis when she was under the age of 13, as alleged in the state's information. And those dates did not require the jury to layer inference upon inference, did not require the jury to speculate. All it required the jury to do was engage in some math and apply its common knowledge, as it is permitted to do, and draw rational inferences from the circumstantial evidence in this case. I'm going to move on to the second issue in this case, which was the prior bad acts, but I do want to note that the state has the alternative argument that even if this court were to conclude that NH may not have been under the age of 13 at the time of the last sexual assault in the barn, the jury could have concluded that he was guilty of count 2 based on his act of penetrating her on his main bed, the bed upstairs on the 2nd floor, and in the barn. 3 separate locations where penetration occurred during the time period alleged in the state's information. And so long as the jury was unanimous, it could have found him guilty for any one of those instances. Turning to,
But based on that, how do you make sure that it's unanimous as to the one act?
well, because the court instructed the jury, it provided a specific unanimity instruction. And it also, and this court has recognized that the presumption that juries follow those instructions pertains to specific unanimity instructions. To affirm, this court is not required to penetrate the veil of jury deliberations and ask specifically which of those, which specific act it might have found the appellant guilty of committing. Instead, it presumes that they follow the specific unanimity instruction unless there is evidence has been provided to conclude otherwise, and appellant has pointed out no such evidence. Turning to the issue of the information that was admitted into evidence about appellant's wife's diabetes port. It became apparent during appellant's oral argument that the parties have different positions on when appellant first started to open the door. During oral argument, appellant asserted that the state's position was that the doors started to be open on cross-examination. That is not the state's position. It's the state's position that appellant started to open the door on direct. And that was done when his attorney asked him straight up, I
Well,
think was.
If I could just, the issue was on the table before the trial actually started, right? And the judge had warned, had, had taken the issue up and suggested there was a close call that was going to have to be made.
There was a lot of litigation about the degree to which various witnesses, including the appellant, should he testify, could impeach one another with information from his conviction for assaulting NH's sister, AH. And there was a lot of forewarning about what would and would not open the door. I will also note that when the appellant attempted, and this is discussed on page 13 of the state's brief, but when appellant attempted to use NH's deposition from this case, not AH's case, to impeach NH, it wasn't necessary for the state to do this, but the state warned appellant that he was on the brink of opening the door to information about AH's case. And despite that warning that he was close to opening the door, on direct, his attorney asked him straight up, that was the phrase he used, whether or not he had herpes. And the appellant's response was, or it was whether he had a sexually transmitted disease, I believe. And the appellant said he had herpes, and he, quote, would never ever transmit that to anybody else, especially a young child. Well, the parties and the judge knew that he had already had sex with AH. So he did have sex with someone else despite his claim that he had herpes. The state followed up on that and asked him whether the fact that he claimed he had herpes was the reason why he was claiming he didn't have sex with NH. And appellant responded, no, I wasn't attracted to her. I have a beautiful wife. To impeach his response that he thinks his wife is beautiful, the state permissibly introduced evidence that he had previously said he was not attracted to her because of her diabetes port. If the appellant had never said that on direct, the door never would have been open and this would not have been an issue.
Attorney Medium, where in the record is that line of questioning?
Apologies.
No, that's okay. I know you know.
It's on page 13 of the state's brief.
Right.
So I believe that it takes place, the comment about the sexually transmitted disease is on May 2nd,
Mhm.
2024, page 140. And then the cross-examination is that same date, transcript 152 to 154.
Thank you.
The appellant argues that even assuming that the door was open, introduction of this evidence was too prejudicial because of the inferences that could have been drawn from it. However, as this court noted in the Desautol case, quote, the trial court is in the best position to assess whether any comment in the context of the trial before it is prejudicial enough to warrant a new trial. And the trial court in this case rightfully relied on the following facts to deny appellant a new trial. The state did not disclose that appellant was under investigation as opposed to being a victim, witness, or person of interest in a case. And in that way, this case is similar to the Rebideau case where the reference was to how I believe it was how a witness knew the defendant and it was from jail. Furthermore, the state did not disclose what the purpose of appellant's conversation with Whitney was. And Whitney said she assisted in other types of cases. Furthermore, the reference to the conversation taking place in 2014 was brief and fleeting. And thus this case is like the Williams case discussed in the state's brief, where there was a reference to the defendant being in custody, arguably more prejudicial than the reference to a conversation with a detective in 2014. Furthermore, and perhaps most importantly, the court instructed the jury that it could only use inconsistent statements for impeachment purposes. In other words, to judge the credibility of the witnesses. And it was not to use that information for any other purpose.
Not as evidence.
Exactly right. Or not for impermissible propensity
Mr. Meenan,
purposes.
we're on time restraints here. Can we get to the jury charge itself on great certainty?
Absolutely, Your Honor. And it's the state's position. There was some conversation at the end of appellant's oral argument about structural error versus plain error. Frankly, it's the state's position that the appellant's reliance on structural error is an attempt to do an end run around the fact they did not object to this instruction and are now subject to a plain error standard of review. If any other conclusion was drawn, then it would mean that any deficiency in a reasonable doubt instruction would be structural error, and therefore there would never, ever be a reason to object to it. And judges would never be able to correct mistakes in real time to make sure that trials are conducted appropriately.
But this judge used great certainty in his charges, I guess on a regular basis. And what is great certainty in your mind?
Well, that's a very interesting question because I think it falls into the same trap that the appellant has fallen into. This court's jurisprudence is clear. We're supposed to review jury instructions as a whole. As a whole, the court's instruction about reasonable doubt was approximately 6 paragraphs long. Appellant has honed in on a single phrase, great certainty. That exercise itself reveals why the argument must be rejected, because we're supposed to review these instructions as a whole.
Well,
And under
you know, you're right. There's a lot of case law to that effect, but there also are a lot of cases, particularly in the federal line, that talk about the mistake happening in one particular instance with respect to this particular issue. I mean, this is an issue, the charge beyond reasonable doubt is an issue that is, I think, elevated in the case law beyond the context that you're suggesting.
Well, I'm not going to disagree with Your Honor that this issue tends to be heavily litigated. And in that context, this court has cautioned judges against attempting to define beyond a reasonable doubt with too much precision. But when we look at the plain error standard of review, which is the error that applies, there's a really important component to that standard. And that is that the error must be obvious. How can this court conclude that this trial court judge made an obvious error when this court has 5 times affirmed that judge's instruction despite challenges from the appellant that are identical to the challenge in this case? In other words, relying on Winship. Now, this court in this decision could say, we're done. Don't use great certainty anymore. Nobody else. I don't want to see it. But does that mean that it was plain error in this case and that there's a reversal of appellant's conviction for sexually assaulting NH? The state's position is no, even assuming that the use of great certainty was a mistake. However, I think it's important to look at what great certainty might mean by doing what appellant suggests and relying on dictionary definitions. And the state relies on 2 in its brief, the Merriam-Webster Dictionary and the Cambridge Dictionary. Some of the dictionaries, those dictionaries have defined great as remarkable in magnitude, markedly superior in character or quality, large in amount, size, or degree, and some synonyms have been astronomical, colossal, gargantuan. Utmost, however, is the greatest or highest degree. There's several others, but I see my time is out. The point being, utmost too closely approximates beyond all doubt to be acceptable. That is not the standard. Thank you very much.
Okay, thank you. Does the appellant have any time remaining?
Appellant has no time remaining.
Call the conclusion of the hearing, please.
The next hearing for the court is scheduled for 9:45 this morning.